Welcome back to Big Law University. This is Big Law University Presents Part 2 of 3 regarding warrants. We're going to be talking about false statements, frank hearings, and particularity. So we're going to go ahead and get started. So in Part 1, we established the foundation. A warrant is a judicial authorization for police action, and for it to be valid, it requires a neutral and detached magistrate, and it requires probable cause built on reliable specific facts. But here's a question that Part 1 left open, and it's one of the most important questions in all of Fourth Amendment law. What happens when the officer who applied for the warrant lied? Or what happens when the warrant itself is vague? When it gives police a blank check to search whatever they want, whenever they want. These are the two issues that we're going to be getting into today. So, false statements, improbable cause affidavits, and what courts do about them, and the particularity requirement, the constitutional rule that prevents warrants from becoming the general search and destroy authorizations that the founders specifically went to war to stop. This is Big Law University. Let's get into it. This is the setup. So we have two suspects and the Seaside Slider. So we're going to call this suspect B and the Seaside Slicer. So to make all of this concrete, we're going to be using a hypothetical running through the entire video. So picture this. We're going to call this suspect, we're going to give him a name. We're going to give him suspect Jimmy, just to make it easier. The police have a suspect, Jimmy, who they believe is the notorious Seaside Slicer, a serial killer, a brutal one who targets only women victims. He binds them, starves them, tortures them for days before killing them. Law enforcement have been hunting this individual for months now. Now, Officer Jack submits a probable cause affidavit to Magistrate Jill. Based on that affidavit, Magistrate Jill issues a search warrant for Jimmy's home. The police execute the warrant. In Jimmy's basement, they find dismembered bodies, cutting implements, caked in dried blood, and other damning evidence that Jimmy is in fact this serial killer. Now, Jimmy's attorney immediately moves to suppress everything. The motion argues that some of the statements obtained in Officer Jack's affidavit were false, and that therefore the warrant should have never been issued. This raises a central question of this entire section. When false statements appear in a probable cause affidavit, what happens to the warrant? So, in plain English, the cops found a serial killer's evidence, but the paperwork that they used to search had some lies in it. Does this mean that all the evidence walks out of the door? That's exactly what Jimmy's lawyer is arguing, and it's a legitimate legal fight. So this is the Franks framework, how the Supreme Court answered this. So the Supreme Court addressed this exact issue in the case Franks versus Delaware, decided in 1978, and the court answered was measured and deliberate. The mere fact that some statements in the affidavit were false is not automatically enough to invalidate the warrant. The court refused to adopt a rule where any lie in any affidavit immediately blows up the entire warrant, because that would be too easy to abuse and too easy to use as a technicality to throw out legitimate evidence. Instead, the court in Franks set up a specific two-stage process: a preliminary hearing, which is then followed by an evidentiary hearing to determine whether the false statements actually matter enough to kill the warrant. But before we walk through those stages, there's a critical principle you need to understand that shapes everything. The purpose of the exclusionary rule, the rule that throws out illegally obtained evidence, is to keep the police honest. It exists to deter police misconduct. And that means the inquiry in a Frank's challenge is focused entirely on what the officer knew and intended at the time the affidavit was sworn. Here's why that matters. If Officer Jack was lied to by a witness and that witness's false information ended up in the affidavit, that does not automatically taint the warrant. Not if Officer Jack had no reason to doubt the witness. Excluding evidence because an informant lied to an honest cop does not deter anything. The cop didn't do anything wrong. Punishing them with suppression does not serve the purpose of the rule. So the focus is always on the officer's state of mind. Did the officer know the statements were false, or did the officer include them in reckless disregard for whether they were true? Those are the questions that drive a Frank's challenge. So in plain talk, the rule is not any lie kills the warrant. The rule is, did the cop lie or act recklessly? If an informant deceived an honest officer, that lie ended up in the affidavit, the officer is not punished for someone else's dishonesty. The exclusionary rule is about deterring police misconduct, not punishing good faith mistakes. Stage one, as I mentioned, the preliminary hearing. The first stage under Frank's is the preliminary hearing. The entire purpose is to answer one question: does this case deserve a full evidentiary hearing? The defendant has to earn that right. The burden falls on them, and it's a multi-step climb. First, the defendant has to identify with specificity the exact portions of the probable cause affidavit that they are claiming are false. Not a general conclusion, but specifically identified statements. Second, the defendant has to submit supporting evidence that raises a fair probability, not certainty, but fair probability that those statements are actually false and that the officer either knew they were false or acted with reckless disregard for the truth when including them. Third, that supporting evidence should include sworn statements from witnesses or other reliable statements, or at a very minimum, a satisfactory explanation for why such evidence is not reliable or is not available. Once the defendant clears those hurdles, the judge performs a mental exercise. They strip out the allegedly false statements and they look at what's left. They ask, does the affidavit still establish probable cause using only the remaining information? If the answer is yes, the remaining true information is still enough for probable cause. Then the warrant stands. The preliminary hearing then ends there. No further inquiry is needed. But if the answer is no, the affidavit will fall apart without those false statements. Then the defendant has earned their evidentiary hearing. So, here's a law school exam tip for you law students out there. The preliminary hearing is a threshold gatekeeping mechanism. The defendant does not get to automatically challenge every warrant just by alleging dishonesty. They have to make specific substantiated showing to even get to the next stage. So in plain English, think of the preliminary hearing as the audition. The defendant is trying to prove they deserve a real fight. If the warrant would still hold up even without the questionable statements, there's nothing to fight about. But if the lies were load-bearing, if the warrant needed them to survive, then the real hearing begins, which is stage 2, the evidentiary hearing. So at the evidentiary hearing, the burden stays with the defendant, but now the standard is even higher. The defendant must prove by a preponderance of the evidence that the officer deliberately included false statements in the affidavit or included them with reckless disregard of the truth. Preponderance of the evidence means more likely than not, more than 50%. This is a real burden, not speculation, not interference alone, but actual proof. If the defendant meets the burden, the judge again strips out the false statements and looks at what remains. Same question as before. Does the affidavit still establish probable cause? If yes, the warrant stands. The false statements did not matter because the honest information was enough on its own. However, if no, the warrant is invalidated. And if the warrant is invalid, the evidence discovered under it gets excluded unless the government can step in and demonstrate that the search was actually reasonable even without the warrant, typically by pointing to one of the recognized exceptions to the warrant requirement. Those exceptions are going to be coming in future videos. 2 stages, 2 strip outs. The false statements only matter if they were load bearing. So in plain English, the whole game in a Frank's challenge is, were the lies necessary to the warrant? If you take them out and the warrant still stands on its own honest legs, the defendant loses. Only if the lies were keeping the warrant alive does the evidence then get thrown out. So back to Jimmy. How does this play out in reality? Let's return to our hypothetical. Jimmy's attorney has alleged that some of Officer Jack's statements were false. Under Frank's, Jimmy now has to navigate this 2-stage process to suppress evidence from his basement. Here's the reality. Jimmy is going to have a very hard time, and part of that is human nature. Judges are human beings. They know what was found in that basement: dismembered bodies, torture implements, evidence of one of the most brutal serial killers in the jurisdiction's history. The idea of suppressing all of that evidence and potentially letting that person walk free is going to create an enormous psychological resistance. Courts will not want to use a procedural rule to free a monster. That's not how it's supposed to work. The Fourth Amendment does not have a guilty people deserve it exception. But the practical reality is that when the stakes are this high, courts will scrutinize every element of the Frank's challenge with maximum rigor. Jimmy's attorney needs airtight proof at every step to have any chance. So here's a law school exam tip for you law students out there. Never assume that a Frank's challenge automatically succeeds because some false statements are identified. Ask yourself, were those statements necessary to establish probable cause? If the honest parts of the affidavit would have gotten the warrant anyway, the challenge fails. Now, the particularity requirement, no blank checks. Now, we turn to the second major issue of this video, the particularity requirement. This one goes all the way back to the founding of this country, and understanding the history makes the rule make sense. Before the American Revolution, British authorities used something called general warrants and writs of assistance. These were blank authorizations that permitted colonial officers to search wherever they wanted, seize whatever they wanted without any specific justification. They were weapons of oppression, and the founders hated them. The hatred is literally written into the Fourth Amendment, which requires that every warrant must, and I'm going to be quoting it directly, particularly describe the place to be searched and the person or things to be seized. The particularity requirement has two distinct components: the description of the place to be searched and the description of the things to be seized. Let's take them one at a time. So in plain English, the founders were not writing abstract legal theory. They had lived under a system where the government could just ransack your home with no specific justification. The particularity requirement is their direct response to that. It says, if you're going to search, you have to tell us exactly where and exactly what, not fishing expeditions. So, describing the place to be searched. On the question of place, the standard comes from Steele versus United States, a 1925 Supreme Court case. The description of the place must be specific enough that the officer relying on the warrant with reasonable effort can ascertain and identify the exact location where the search is authorized. Notice the standard is reasonable effort, not perfection. Minor typographical errors, small inconsistencies, typos in addresses, none of those automatically invalidate a warrant. Courts look at the totality, again, of the circumstances and whether the police could reasonably identify where they were supposed to go. But here's the line. If there is a significant risk that relying on the warrant as written would search the wrong place by mistake, that description is not particular enough and the warrant is invalid. The specificity requirement exists precisely to prevent police from ending up in the wrong house. So in plain English, your address on the warrant has a one-digit typo, courts usually let that go if the overall description makes the right location obvious. But if the warrant is so vague that a different person's home could reasonably match the description, that's a constitutional problem. Now, describing the things to be seized, the second component, what can be seized, is where things get more complex. The Supreme Court established two foundational rules here, both shaped by the case of Marin versus United States, decided back in 1927. So, Rule 1, police may only seize the person or things actually described in the warrant from the place described in the warrant. Rule 2, the description must be so specific that nothing is left to the discretion of the officer executing the warrant. There should be no room for the officer to exercise subjective judgment about what they're looking for. The warrant tells them, the warrant controls. A warrant that simply authorized police to rummage through someone's belongings for evidence of a crime is unconstitutionally broad. Full stop. The standard articulated by the Fifth Circuit in the United States versus Cook in 1981 is that the warrant must enable the searcher to reasonably ascertain and identify the specific things authorized to be seized. So in plain English, the officer executing the warrant should be able to read it and know exactly what they're looking for. The warrant is not a permission slip to go on a treasure hunt. It is narrowly defined authorization. If the officer has to use their own judgment to figure out what falls under the warrant then is too broad. So, when generic description when the generic descriptions are and are not acceptable. Now, reality check. Police often don't know exactly what they are going to find before they search. They cannot always provide a precise, itemized list of every object they expect to seize. Courts recognize this, and the rule is that the description should be as specific as it reasonably can be under the circumstances. So sometimes generic descriptions are fine. Courts have approved language like U.S. currency, gambling paraphernalia, and tools used in manufacturing of gambling paraphernalia, and stolen goods that have trafficked in interstate commerce, including boots, suits, and coats. These are general, but they are still specific enough to guide the officer's conduct without leaving everything to their personal judgment. Generic descriptions are especially acceptable when the items in question are instantly recognizable as contraband. The moment an officer sees them, there's no discretionary call to make. So something like narcotics and tools of their manufacturer and distribution process passes muster in most courts because the items either are drugs or they obviously are not. But, and this is the critical limit, when the police have enough information to be more specific, generic won't cut it. So if the officer already knows the specific types of implements being used, specific items of clothing from specific victims, specific tools, and they describe the target items as simply all evidence tending to implicate the suspect in the murders, that is too broad. The officer has the information to be more precise and they did not use it. The warrant gets struck down. One more rule worth noting: a description that requires officers to interpret the law, like authorizing them to seize illegally obtained films, is almost certainly too broad. You're now asking the executing officer to make a legal determination in the field. That's not their job. And it injects exactly the kind of unconstrained discretion that the Fourth Amendment was designed to eliminate. So, law school students, here's an exam tip. The particularity question for things to be seized is always a two-part prong. First is the description as specific as it could have been given what the police actually knew. And second, does this description require the executing officer to exercise the legal judgment? If either fails, it is a constitutional problem. So, the hypothetical, applying this to Jimmy. Let's bring Jimmy back and put these rules to work with two concrete questions. So, assume there are no false statements in this affidavit. Magistrate Jill issues a search warrant for Jimmy's residence at 123 Make-Believe Lane, California. The address is correct, but when the magistrate fills out the warrant, the magistrate leaves the space for persons or things to be seized completely blank. The officer's affidavit contained an adequate description, but the warrant does not reference or attach that affidavit. So, question 1, is the warrant valid? No. The place description is fine because it has the correct address and there's no ambiguity about it, about which location is authorized. But the warrant is fatally defective on the second component. The space for what is to be seized was left blank. Nothing. Not even a reference to the affidavit. Now, could the warrant have saved itself by attaching the officer's affidavit and explicitly incorporating it by reference? Probably yes. If Jimmy is handed a warrant and can read the affidavit as part of the warrant package, he knows what the police are looking for. But that's not what happened here. The warrant goes to Jimmy and the officer with a blank with a blank where the item should be. Neither of them can tell from the warrant alone what is authorized to be seized. The Supreme Court addressed exactly this situation in Groh versus Ramirez. Decided in 2004, the court confirmed that a warrant which fails to describe what is to be seized is constitutionally deficient. The particularity requirement is not satisfied and the warrant is invalid. In plain English, you're handing someone a search warrant with a blank where the list of items should be. That's not a specific authorization. That's an invitation to take whatever you want. The Fourth Amendment does not allow that. The warrant fails. So, question 2. What if, instead of a blank, the magistrate wrote all evidence tending to implicate Jimmy in the string of the gruesome murders commonly attributed to the so-called Seaside Slicer, which was the nickname given to him? And we know that the officer at the time of applying for the warrant already had specific knowledge. He knew that Jimmy, the serial killer, would bound his victims with leather straps. He knew the specific types of cutting and electrical implements used to torture the victims. He knew what kind of scalpels and knives were used. He had information about the victims' families and about what each victim was wearing when she disappeared. With all of that information already in hand, is the generic description adequate? Probably not. Generic descriptions can be acceptable when specificity is genuinely impossible, when a police did not know yet what exactly they would find. But that's not this situation. The officer knew what they were looking for. They had specific items in mind. They had the information necessary to write a more targeted description. They chose not to, or probably just didn't bother. A description of all evidence tending to implicate Jimmy's is so broad that it effectively authorizes the officer to rummage through the entire house looking for anything that might be incriminating. That's the general warrant for the founders were trying to prevent. When the officer had enough information to be specific and was not, the warrant is likely invalid. So in plain talk, all evidence of the crime sounds thorough, but legally it's a blank check. If the officer already knew about the leather straps, the specific tools, the victim's clothing, they needed to list those things. Knowing what you're looking for and still writing a vague warrant is exactly the problem the Fourth Amendment was designed to fix. So, 2 major doctrines today, let's seal them in. On false statements and affidavits, the rule from Frank versus Delaware is this: lying in an affidavit does not automatically kill the warrant. The defendant has to earn suppression through a 2-stage process: preliminary hearing, then evidentiary hearing. Proving that the officer intentionally or recklessly included false statements and that those statements were necessary to establish probable cause. If the honest facts still support the warrant, the evidence stays in. On particularity, the Fourth Amendment demands that every warrant specifically describe the place to be searched and the things to be seized. Minor errors in the place description are forgiven if the right location is still identifiable. But the description of what to seize must leave nothing to the officer's discretion. The more information police have before applying for the warrant, the more specific they are required to be. And a warrant that makes the officer interpret what is or is not evidence of a crime, the warrant is too broad. For law students out there, these are the 2 main ways a facially valid warrant can still be challenged. Memorize the Frank's 2-step and know both components of particularity cold. They show up constantly in criminal procedure exams and, more importantly, in real courtrooms. Part 3 of Warrants is coming. We close out the warrant series with the execution rules, how warrants must be earned, how warrants must be carried out once they are issued, and what happens at the boundaries. So don't skip it. Subscribe to Big Law University. Drop a comment if this video helped you, and share it, because somewhere out there, someone about to take criminal procedure exam needs exactly this. Big Law University, know the law, own the room.